LifeSpan, Lifetime Secure Personal Assistance Network, is an organization almost 20 years old now that is focused on working with families to provide secure and meaningful good lives for their loved ones with a disability throughout their lifetime. So a lot of the attention in the last several 5 decades, I would say, since my sister was born, has been on early learning, K-12 schooling, transitions into jobs and things of that sort, maybe some on housing. But we are the ones that really look at the lifetime, and in particular, the adult lifetime of people with disabilities. And so things like estates and all that kind of planning are the kind of thing we're really interested in. So with that, I'm going to turn it over to Katie to begin the presentation.
All right, thank you. And for those of you who haven't used Zoom, if you're wondering about the chat function, it's right at the bottom of your screen, and it'll say chat. You can click that up. You can either send a chat directly to Michelle, which is probably the best, or I think the default is to send it to everyone. But we are going to go ahead and get started. So today we're going to be talking about financial tools, how to use trusts and ABLE accounts, and I work with Cassidy Monero PLC. They are a law firm that specializes in disability issues, including special education, guardianships, the things that I do that Michelle conveniently listed off for me. You will see on the very first slide that it has the date of this presentation, the name of my firm, but it also has my email address. So if anybody has follow-up questions, you can send an email to me. I am not, and this is just a disclaimer at the start, is that I am not able to give direct legal advice in this forum or without engaging a client. That is due to legal ethics rules that I need to be able to establish an attorney-client relationship before I give specified legal advice. So today I'm going to be providing educational material for you guys. So hopefully that you can translate this into your life, and then you can assess for yourself if it's time to engage a professional or if you feel confident going into some of these things on your own. Let's see if I can. So the financial tools that we're going to be covering today specifically are special needs trusts, and 3 types of special needs trusts: first-party special needs trust, third-party special needs trust, and very briefly, I'm just going to touch on the DD Endowment Trust. It's also called the DD. It has previously been called the Life Opportunities Trust or the DDLOT Trust. But I'm just going to briefly mention that one. And then I'm going to talk about ABLE accounts. At the end of talking about special needs trusts, I'm going to pause for questions. And then we're going to move on to ABLE accounts. At the end of ABLE accounts, I'm going to pause again and call for questions that Michelle has nicely agreed to monitor for me. And then after ABLE accounts, I'm going to go through some examples that I have provided in the handout. And I was looking at the chat briefly before I started that some people have not gotten the handout. I will be reading the example out before I discuss it. Okay. So why are these financial tools necessary? Why are we even talking about this? Well, we are talking about this because there are a number of reasons why you may want to establish an ABLE account or a special needs trust for your family member. The first of which is management of assets. To assist an individual with a large sum of money. Trusts are used for all sorts of family dynamics. They are commonly used with children of not just minor children, but older children as well, as a routine part of estate plans. It is a way to help somebody manage a sum of money or a property that they may not otherwise be equipped to handle or may not be used to handling. The one that really usually gets people's ears perked up is the preservation of needs-based benefits by creating an exempt resource. And that's usually what brings people into my office, is that they're like, oh, we have this sum of money, we want to leave it to our child who has a disability and they're on SSI, how do we do that? And both the ABLE account and the special needs trust are kind of the two main ways that we use to deal with that. So special needs trusts and ABLE accounts preserve eligibility, financial eligibility, and those needs-based programs, for those of you who have been on them, you know that they do not provide for everything. So what is a trust? A trust is a legal entity. It is created to hold assets for the benefit of a particular person or class of persons. When we are talking about special needs trusts, we are talking about one person. So if you have multiple children with disabilities, you have to have multiple trusts. Each trust has to be for one person. A trustor can also be called a grantor, and that is the person who established the trust and funds the trust for the purposes of our conversation. The trustee is the person who is in charge of the assets once the trust is funded, and the beneficiary is the person who benefits from the trust. When we're talking about the different types of trusts, I'm going to be coming back to those terms. So a first-party special needs trust. The roles. The trustor or the grantor is the individual with the disability. That it means that the money that is going into this trust was originally held by the individual with the disability. A lot of people say, well, they were on needs-based benefits. Why would they have money that would need to go into a trust? Oftentimes it is that the individual is has been in a lawsuit, has been injured in some way, and that a settlement or a judgment has come in their favor, and now they have $2 million from a settlement or even $10,000 from a settlement, and that money needs to go somewhere, or else it may be counted and kick them off of their benefits. So that would go into a first-party special needs trust. Similarly, if an individual inherits money directly from someone, so either a parent or a grandparent did not include a special needs trust in their will and just said, my estate to be divided equally among my children, and does not provide for a special needs trust, and one of their children is on a needs-based benefit such as SSI, that money technically belongs to that child at the death of the parent. So then a first-party special needs trust would need to be set up. There are ways to avoid that, and we're going to talk about that briefly in a minute. The trustee in a first-party special needs trust is an individual or entity that you trust. Depending on how large the trust is, or whether or not I would recommend a professional or and the beneficiary is the individual with the disability. First-party special needs trusts are created by federal law and monitored by Social Security and audited somewhat frequently. So they need to follow some particular rules. The money can only be used for what's called supplemental benefit. So there needs to be this language in the trust that says that the money that is in the trust can only be used for something that would not otherwise be covered by a governmental benefit. So what that really means in practical terms is that if the individual is on SSI, and SSI is supposed to cover basic food and housing costs. SSI at its max is $745-ish. I would challenge anybody to try and find an apartment and buy groceries on $745 in King County, but that is what it is supposed to be covered for. Therefore, special needs trust should not be used to pay for rent or for groceries, but it can be used for entertainment, it can be used for travel, and it can be used for kind of just anything else other than rent and basic food and housing. The trust needs to be set up before and funded before the individual with the disability turns 65. The payback provisions, the trust needs to include language with Medicaid payback provisions. A first-party special needs trust at the death of the beneficiary, Social Security comes in through department within the state of Washington if you're living there, and anything that is remaining in the trust is used to pay back what that individual has used in Medicaid benefits during their lifetime. If the individual has used $50,000 in benefits and there's only $10,000 left in the trust at the time of the individual's death, the entirety of the trust will go to the state at the time of the beneficiary's death. If it's reversed, that the individual has only used $10,000 in Medicaid benefits, but there's $50,000 remaining in the trust at the time of the individual's death, then the state would collect $10,000 and the remaining $40,000 will be distributed according to the individual's will, if they had one, or according to intent law. The trust also needs to be for the sole benefit of the individual with a disability. Like I said, if you have multiple children with disabilities, there needs to be separate trusts for each one. The trust needs to be discretionary, meaning that the trustee has full power over what money is spent. That means that there can't be automatic pay provisions. In a trust, how that looks is that some trusts will be written in such a way that says, oh, at the individual's 35th birthday, they receive 1/3 of what is remaining in the trust. Cannot do that with a special needs trust. The individual cannot have the power to demand money, because if the individual has power to demand money, Social Security will say that they own that money and that they could then use that, and it's an available resource. The trust also needs to be irrevocable. That means once the trust is established and once it's funded, you can't get it out for any purpose other than the purposes laid out in the trust. This became a particular issue when I was working at a law office during the recession, and I'm sure it's becoming an issue currently too, where a lot of money is tied up in a trust, and suddenly the family feels like they need that money and want to go in and terminate the trust. Yeah, that's not going to happen. So I recommend, if you're, just know that when you're putting money into this trust, you're not getting it back out except for the benefit of the beneficiary. So third-party special needs trusts. This is the trustor or the grantor is anybody except for the individual with the disability. The trustee, again, is an individual or a professional whom you trust to use the funds appropriately. and the beneficiary is the individual with the disability. Rules, there are less rules with a third-party special needs trust. Money does still need to only be used for supplemental needs, meaning no basic food and housing, can't use this to pay for rent. Again, it's a sole benefit rule, have individual trusts for individual people. The funding needs to be discretionary. Like I said, the beneficiary cannot have the power to demand money. And the trust, once again, needs to be irrevocable. You will notice the things that are not present in here are that there is no Medicaid payback provision in a third-party special needs trust. There is also no requirement that the individual is under the age of 65. So DD endowment trusts, I'm not going to be going into this with significant detail, but I do just want to call it out that there is an option in our state with if the individual with the disability is a DDA client, I recommend looking at DD endowment trusts. They're a type of pooled trusts that are managed by the ARC of Washington. And I'm not saying that just because I'm a board member of the ARC of Washington. My brother had a DD endowment trust, I believe, before I was on the ARC of Washington's board. My mom is upstairs. We are quarantining with my parents, and she is saying yes, it was before that. Thank you. It's a combination of rules between first and third party, but there are first party trusts and third party trust options, but they are called type 1 and type 2. Type 1 trusts are third party trusts and type 2 trusts are first party trusts, just to make it difficult. No, it's not just to make it difficult. There's a reason, but I don't need to go into it. And so if you're looking into trusts, I encourage you to go to their website. They have fantastic resources. And one of the reasons why you may consider a DD trust is that then you don't have to have a trustee. You don't have to be the trustee and manage the administration of the trust. The ARC of Washington does that. However, the trade-off is that you are not the one managing it. The ARC of Washington is. So it's just a fit for different people. Okay, so benefits and drawbacks to trusts. And this will become, and I'm going to revisit this as well after we talk about able accounts. But benefits of a trust are that there's a definite form of asset management. So after the death of a parent and the parent wants that money to be managed, that the individual who is managing the assets has to keep good records and that anybody can demand the records. So make sure that it's somebody who is organized and that you can trust to manage these assets. Benefit is definitely preservation of benefits. It's a less restrictive form of guardianship of the estate, potentially. If the individual is able to manage small sums of money, but not large sums of money, you can put large sums of money in a trust, and then the individual can manage their own small sums of money. Again, these are very individualized decisions for families. There is no money going directly to the individual if the individual is not able to manage that money. That is something that is important, is that these trusts are buying things directly from the third-party provider. So for example, if the individual, the beneficiary, is moving into a new apartment and wants to furnish that apartment with furniture, TV, whatever, The trustee should pay either the trustee brings the trust checkbook to IKEA, whatever, to write the check directly from the trust to pay IKEA, or if they have a designated person who is trusted to go with the person, and then they can reimburse that person for the purchase. But keep receipts. Want to be able to show that you didn't just pay the beneficiary's sister $1,000 for no reason. You want to say, oh, the $1,000 went to a table and chairs and a couch. Another benefit of the trust, specifically for if you are a parent leaving money to an individual and you're saying, why do I need to do a trust? Can't I just leave it to my typically developing child and say, I trust them completely, let them take care of their sibling for the rest of their life? Please, for the love of all that is holy, do not do that. And I could see Michelle going, there are a number of reasons not to do that, but the four that I always want to call out to people are the 4 Ds of death, divorce, disability, and disaster. For death, that the sibling dies without doing adequate planning, dies very recently after the parent dies, and then there's no planning for the individual with for the child with the disability. And child to indicate like offspring, not minor. Divorce, that the sibling gets a divorce, it would be considered separate property so long as it isn't commingled. However, it would be considered in the divorce as that individual's property, so the sibling then would get less of a share of their marital property during their divorce. Disability, that the sibling gets in an accident and becomes disabled for whatever reason, or the sibling starts to age and is not able to manage that money anymore. Or disaster, the sibling gets in a car accident and gets sued, and now all of that money is available for judgment. So there are a number of reasons not to do it, not least of which is that it also puts the sibling in a really difficult position. Drawbacks and costs of the trust, the actual financial cost of creating a trust. Trusts can be expensive to create. Trusts are currently taxed at a higher rate than individuals. I do not go into the taxes. Please don't ask me questions about the taxes, because if they get particular, I'm going to refer them to an accountant. The burden of trust administration, like I said, you need to keep really good records when you're doing a trust. No money goes directly to the individual. This can be I put it both in the benefits and the drawbacks. Some people want to have a certain amount of an allowance to go to the individual that they manage themselves. That's not an option in special needs trusts except in very rare circumstances. And they need to be finessed, and yeah. Also, a potential drawback is education of trustees that are not professionals. So if you name the sibling as a trustee, you need to educate them that this can't be used for rent. There are strict penalties for using it as for non-allowed purposes, including potentially Social Security coming back and saying, oh, this trust has been used for rent, therefore this is an available resource, and the individual is kicked off of Social Security. I've seen that happen. It is a mess. We have been able to get people back on, but oftentimes you have to appeal decisions with Social Security, and you don't want to go there. Yeah. So I'm going to pause now for questions on special needs trusts.
Thank you, Katie. This has been wonderful so far. So I've been following the chat and I've jotted down. There's a lot of questions about ABLE accounts. We'll be getting to those
Okay.
shortly. So I'm going to try to pull out the ones that were more specific to special needs trust. Some of this could be more like a checking for understanding, like did we hear correctly what you said? So
Perfect.
to confirm perhaps. So one question was just to double check that if it's a third party trust, then there's no payback to Social Security, correct?
Correct. And a brief thing on that, again, with the educating of trustees, is that if you accidentally put money that was owned by the beneficiary into a third-party trust, if Social Security does an audit, they're going to say, this is now a first-party special needs trust. Go edit that third-party trust document and amend it to make it a first-party trust. So you want to be
So you have to be really careful. So
Do not
third
put.
party is really somebody else's money, not the person that is the beneficiary of it.
Yes.
Sort of related to that, that they understand that Social Security does want to know about the first party trust because there is that payback provision. Do they also need to know about the third party special needs trusts?
I'm so sorry. What? I'm going to mute myself.
So, I mean, you sort of actually gave an indication because it sounds like Social Security could audit even if it's a third party trust just to make sure that it doesn't have any first party money. Is that true? Or do they need to even know about a third party trust?
Michelle, hold on one minute. 1 second.
Okay, good. Yeah, right now we're just on the question.
Sorry.
Yeah,
sorry,
okay.
my child was trying to come in.
Okay, got it. Okay, so this question is, does Social Security need to know about a third-party trust since there's no payback on it?
You do not need to report the third-party trust preemptively. However, if they ask about it, you have to disclose it.
Okay, so you don't need to say something in advance, but if they ask, then you have to say. Okay, now.
So how this kind of works out is a third-party trust technically isn't the money of the beneficiary. The beneficiary doesn't own that money.
Right.
If they are seeing income coming in to that individual's bank account, they're going to say, where is this money coming from? And at that point, that's where we get in trouble with the and that if then you say, they're like, where is this money coming from? And they say, oh, it came from this trust. And they say, oh, look, an available resource. That's how it happens.
There was a question about the funding of first party special needs trust that I think was confused. If you could just restate that if I've understood correctly, the first party special needs trust has to be funded by funds that belonged to the beneficiary. They can't be from somebody else like a parent.
No, they can be from other people. I just don't recommend that because of the Medicaid payback provision. So if you only want to create one trust and it is initially funded with an inheritance or a judgment for the benefit of the individual with a disability, other people can contribute to that trust. I just don't recommend it.
Got it. So the main thing is that the person's, that is the fund where the person's money should go. The person's money can't go to a third party.
Right.
Yeah. Okay. Some questions about Section 8 vouchers and third-party special needs trust.
Yeah.
Let's see. Well, actually, this maybe had to do with ABLE, I think. I think the idea is if you take money out of a special needs trust, does that impact your income, so to speak, calculations for qualifying for SSI?
So Section 8 is very complicated when it comes to special needs trusts. The law is unclear, but I have had a few cases in Seattle, Greater King County area, and one in Tacoma, where, and this was a few years ago, where they were counting distributions from a special needs trust, even though they were not distributions to the individual. So Social Security and Section 8 are in two different agencies in the government. One is Housing and Urban Development, that's Section 8, and one is Social Security Administration, that's SSI, Social Security. Social Security, that's what we're protecting with a special needs trust. Section 8 doesn't particularly respect special needs trust.
Okay, so that is a good thing to be careful of. A question about if you have a term life insurance policy to provide funds in the event of the death of the parents, is there any way to have a provision so that it would fund a special needs trust rather than going directly to, say, to a sibling?
Yes, and you want to check with your insurance provider specifically, because each one of them will have a specific way that they want you to word it. Some life insurance companies make it a requirement that the trust is in existence before your death, so that the trust can't be created by your will. It needs to be created and funded prior. That is one way of doing it. Other ones are fine with saying that it needs to go to my estate. Other ones say that they need it to say that it needs to go to the testamentary trust for the benefit of Catherine J. Hurt. You just need to check with your insurance provider.
Check with insurance, but it's something to think. I want to go back and clarify Beth Angela's question. She is saying that when you open the first party special needs trust, it needs to be seeded by money that is not the beneficiaries. Is that true?
No, you can seed it with your own money. In fact, most people do seed it with like if the parent is establishing the trust, $100 just to open the bank account.
Yeah, the question was, can you use the beneficiary's money to seed it, or does it
yes,
have
you can.
So either way, you could open it with money from the parents or money from the person.
Yeah, I don't, and as soon as I said yes, definitely, I know that the parent needs to create the trust. So oftentimes, so that in the law, a parent, grandparent, guardian needs to, or court needs to create the trust. With court-ordered trusts, it is almost exclusively funded initially with the funds from the beneficiary that were previously owned by the beneficiary. With parents, when I set them up, usually just as a matter of convenience, we set it up with the parent opens the account, because it's usually about $25 to open a bank account. And then that money can be refunded to the parent if needed.
Okay, so it sounds like there may be a little unclarity. Beth Angela was told by her lawyer that the parents had to provide, they had to do the seed money. So that's not completely clear.
And the law says that the parent needs to establish the trust. It depends on how you view establish. I would recommend having the parent just open up that bank account, because it's not like it needs to be funded with $1,000. It needs to be funded with whatever the bank needs an account to be started with.
Okay. Great. First of all, I also want to just say I apologize, everybody, that we're having a little bit of throughput problems here and there. Katie, sometimes we're not quite hearing you, and
no.
Usually you're repeating or making it clear after you've said something, but just in case, just be aware of that. We're sorry. It's obviously it's probably that time of day where everybody is on the internet right now, and it's just not getting a lot of throughput. That's really helpful. I think most of the other questions relate to ABLE accounts in some way too. So maybe we can take those and, I mean, continue with the presentation and then go back to any other questions that have been missed.